In a move that's left gun owners scratching their heads, the Trump Department of Justice just filed a brief defending one of the oldest gun control schemes in American history. And get this, they're using the exact same anti-gun talking points we'd expect from the Biden administration. Today, we're breaking down why the DOJ is fighting to keep the National Firearms Act alive, even after Congress eliminated the taxes that supposedly justified it in the first place. Hi, I'm Alex and you're watching 2A Updates. The Department of Justice just made its position crystal clear. They want to keep the National Firearms Act intact, even though the constitutional justification for it literally doesn't exist anymore. This isn't just disappointing. It's a fundamental betrayal of the Second Amendment, everything this administration claimed to stand for on gun rights. Let me bring you up to speed on what's happening here. Back in July, Congress passed the One Big Beautiful Bill Act. During the legislative process, there was a massive push to fully deregulate short-barreled rifles, short-barreled shotguns, suppressors, and any other weapons, what we call AOWs, from the National Firearms Act's taxation and registration requirements. The goal was simple, complete repeal of these restrictions. But here's where things went sideways. An unelected bureaucrat known as the Senate parliamentarian stripped out the removal of registration requirements from the final bill. What we were left with was just the removal of the tax. The $200 tax stamp, gone. Set to $0. Now, you might be thinking, well, at least that's something, right? Sure. But here's the thing, and this is critical to understand. The National Firearms Act wasn't passed as a gun registry. It was passed as a tax collection scheme that happened to create a registry showing people had paid their taxes on these firearms, and we know from Supreme Court precedent, specifically U.S. versus Sonzinski and U.S. versus Constantine, both from the 1930s, that a $0 tax, a tax that generates no revenue, isn't actually a tax at all. It's something else entirely. Which means the entire constitutional foundation that the NFA supposedly stood on just collapsed. That's exactly the argument that was made in the lawsuit challenging the NFA, filed the same day the One Big Beautiful Bill became law. For months, we've been waiting to see how the new administration would respond. Would they recognize that the constitutional justification evaporated? Would they do the right thing and let this antiquated gun control scheme die? Well, on November 20th, we got our answer. And it's not good. The Department of Justice under Pam Bondi filed its memorandum in opposition. In plain English, they're asking the court to reject the constitutional challenge and uphold the NFA. They're defending gun control. Let me read you exactly what the DOJ argued. Plaintiffs claim that Congress's taxing power can no longer serve as the constitutional source of the NFA's requirements on manufacturing, transferring, or possessing short-barreled rifles and shotguns, suppressors, and AOWs because those firearms are now untaxed after the OBB enactment and therefore produce no revenue. But that claim suffers from an obvious flaw. Contrary to what plaintiffs contend, business in these firearms is not untaxed. Their argument, even though the transfer taxes are now $0, the NFA still taxes manufacturers and dealers through something called the Special Occupational Tax, or SOT. Therefore, they claim the NFA still generates revenue and is still a valid exercise of Congress's taxing power. Let's pause here, because this argument is absolutely insane. What the DOJ is essentially saying is this. Even though Congress repealed the tax on individual gun owners, the entire registration scheme is still constitutional because manufacturers pay a different tax. That's like Congress repealing the personal income tax and the IRS still demanding you file a tax return on the theory that businesses still pay sales tax. It makes zero sense, and here's what really exposes how dishonest this argument is. Let's look at the history. The National Firearms Act levied a $200 tax on these items back in 1934. That's equivalent to nearly $5,000 in today's money. The entire point was to make these firearms so expensive that regular Americans couldn't afford them. It was never really about generating revenue from manufacturers. It was about pricing poor and middle-class people out of exercising their Second Amendment rights. The special occupational tax that the government is now hanging its hat on, that's just a $1,000 yearly fee that dealers and manufacturers pay, so they don't have to pay the $200 tax on every single item they make or transfer. It was always ancillary to the main tax scheme. It had nothing to do with the registration requirements on individuals who now pay $0 for their tax stamps. What the government is trying to argue is that because one part of the NFA still generates some tax revenue somewhere, that must mean the entire thing is constitutional, including forcing individual gun owners to register their firearms for a $0 tax. It's a terrible argument. It defies basic logic. But wait, it gets worse. The DOJ doesn't stop with a taxing power argument. They go on to claim that even beyond the taxing power, Congress has authority to keep the NFA under the Commerce Clause. They argue that because the NFA regulates interstate transfer of firearms, it's constitutional as a regulation of commerce, tax or no tax. Think about what they're saying here. This is a massive expansion of federal power. If the federal government can register NFA items simply because they move in interstate commerce, then by that exact same logic, a registry of all firearms, not just suppressors and short-barreled rifles, but every single gun in America, will be justified under the Commerce Clause. Is that really the position the Trump administration wants to take? That the federal government has unlimited power to create gun registries as long as firearms cross state lines? Because that's what this argument leads to. And they're still not done. The DOJ also invokes the Necessary and Proper Clause. Let that sink in for a moment. The Necessary and Proper Clause gives Congress the power to make laws that are necessary and proper for executing its constitutional powers. The DOJ is now arguing this gives Congress broad authority to enact federal gun control laws like the NFA's registration scheme. In other words, they're saying the Necessary and Proper Clause is essentially a blank check. Congress can pass virtually any gun control it wants, and courts should defer to that judgment. There's no limiting principle here. If this argument succeeds, what can't Congress ban or regulate? The implications are staggering. This isn't about the NFA anymore. This is about whether there are any limits on federal power when it comes to the Second Amendment. And just when you think it couldn't get more offensive to gun owners, the DOJ's brief is absolutely packed with anti-gun buzzwords and rhetoric straight from the gun control playbook. They cite opinions calling NFA items weapons of war. Weapons of war. That's the exact phrase that gun control advocates have been using for years to demonize semi-automatic rifles and standard capacity magazines. Why is the Trump DOJ using that language? And here's the irony that apparently escaped everyone at the Justice Department. Weapons of war are exactly the types of arms the founders intended to protect with the Second Amendment. The whole point was for citizens to have access to military-grade weapons so they could serve in militias and defend against tyranny. But now the DOJ is using weapons of war as a justification for control. The brief continues with more anti-gun talking points. Let me read you some of these gems. Historic laws targeting dangerous and unusual weapons mirror the NFA in their purpose. Short-barrel shotguns are uniquely attractive to violent criminals. The NFA's regulation of short-barreled rifles targets a concealable weapon likely to be used for criminal purposes. Seeking to curtail armed crime, the NFA targeted particularly dangerous and easily concealable weapons that could be used readily and easily by criminals. Uniquely attractive to criminals. Particularly dangerous. Easily concealable. Used for criminal purposes. This is the language of gun control advocates. This is Bloomberg talking points. This is Everytown rhetoric. And it's coming from the Trump Department of Justice. Let me be clear about something. The Trump administration has done good work on Second Amendment issues in many areas. Judicial appointments have been solid. There have been positive policy moves. But this is a disaster. This is the DOJ taking perhaps the most expansive view of federal power we've seen in decades, all in service of defending a gun control scheme that lost its constitutional justification when Congress zeroed out the tax. The DOJ is also claiming that these firearms are particularly susceptible to criminal misuse. Really? Let's follow that logic. Handguns are used in the vast majority of gun crimes in America. Are they particularly susceptible to criminal misuse? Can those be banned too under the DOJ's reasoning? Because if susceptible to criminal misuse is the standard, then virtually every firearm in America could be regulated, registered, or banned. That's not the rule of law. That's not constitutional governance. That's judicial tyranny with a thin veneer of legal language. Here's what's really at stake in this case. If the DOJ succeeds with these arguments, the floodgates are open. The federal government will have established that it can maintain gun registries even without a tax, that the Commerce Clause gives it sweeping power over firearms, and that any gun deemed dangerous or attractive to criminals can be heavily regulated or banned. This isn't just about suppressors and short-barreled rifles anymore. This is about the future of the Second Amendment itself. So where do we go from here? The legal team challenging the NFA will file their response, breaking down exactly why the DOJ's arguments fail. This case is far from over. But gun owners need to understand what's happening here and what's at stake. We were told this administration would be different on guns. We were told they'd respect the Second Amendment. Yet here we are, with the Trump DOJ using anti-gun rhetoric and expansive theories of federal power to defend one of the oldest gun control schemes in American history. The fight continues. The truth needs to get out there. And gun owners deserve better than this from an administration that promised to protect their rights. Thanks for watching. Make sure to like, comment, and subscribe to stay updated on this developing case and all the latest threats to your Second Amendment rights.